Hello, my name is Richard Jackson and I'm the founder of the GateSafe charity. GateSafe was set up in the wake of two separate incidents involving children which took place in June and July 2010. Both cases involved a child becoming trapped in an automatic gate, and tragically, each accident proved fatal. Since then, GateSafe has campaigned tirelessly to improve the safety of automatic gates and to raise awareness of the need to observe the correct protocol to deliver a safe and compliant gate. Today's podcast marks the first in the series and addresses the important subject of the legal responsibilities for any installer involved in the installation of automatic gates. In addition to the two cases which were the catalyst for starting GateSafe, sadly there have been many more incidents and fatalities associated with unsafe manual and automatic gates, and the ensuing court cases have resulted in fines ranging from £12,000 to £80,000 and even a jail sentence. I'm delighted to announce that GateSafe is now working with a specialist legal firm that can provide the required professional and expert counsel to assist installers, gate owners involved in disputes or legal proceedings associated with an automatic gate. Helen Devery and Nick Gianferrari are partners in BLM and experts in health and safety law. They've acted for individual installers and companies charged with breaches of health and safety offences, including gross negligence and corporate manslaughter. Helen and Nick, thank you both so much for joining us today and taking part in today's podcast. Helen, could I ask you to tell us a little bit about your position and your involvement in legal cases involving automated gates?
Thanks, Richard, and thank you for asking us to be involved. Nick and I are partners at BLM. We're a national insurance litigation firm. We specialise in health and safety law. We have a team of 25 lawyers, and Nick and I have worked together for many years. We've both been involved in many high-profile health and safety cases involving, sadly, a number of fatalities, and this has also touched upon fatal accidents in the gate installation community, where we've acted for individuals and organisations alike.
Could I ask you to talk about the different liabilities that an installer might face?
Yes, I mean, in simple terms, Richard, essentially, if somebody is killed or injured as a result of a defective installation or an alleged defective installation, then the installer could face both criminal charges arising out of breaches of health and safety law, as well as civil charges, which essentially are claims for personal injury or claims arising from the estate of somebody who's been killed. There are two distinct sort of areas of law. Criminal law has a much higher burden of proof, so there has to be you have to prove beyond reasonable doubt somebody's culpability, whereas in civil claims, personal injury claims, you're only proving on the balance of probabilities. I think what surprises many installers is that they can be cleared of a criminal charge but sued successfully for personal injury because of the difference in this burden of proof. But invariably what will happen is that if there is a major incident involving somebody being injured or sadly killed, there will be investigations by the HSE and by the police if there's a fatality, and there will I would assume also be a claim made by the individual or their family. So they're likely to have a number of potential proceedings for which they're being investigated, prosecuted or sued.
Thank you for that. Can you talk about the difference between corporate manslaughter and gross negligence manslaughter?
Yes, basically, if somebody is injured, then they're going to be investigated for health and safety offences. If somebody is sadly killed, then there's a possibility that they may be investigated for manslaughter charges. So turning first to what is corporate manslaughter, well, the clue is actually in the name. This is not against an individual. This is against a company or an organisation. And an organisation can be convicted of someone's manslaughter if it's mismanagement, and that's an important word. Mismanagement amounts to a gross breach of a duty of care. The Corporate Manslaughter Act says that an organisation will be guilty if the way in which its activities are managed or organised, causes someone's death, and amounts to a gross breach of a duty of care owed by that organisation to the deceased. So an organisation will be guilty if the way its activities are managed or organised by senior management is a substantial element of the breach. So it has to be senior people within the organisation. Now, the smaller the organisation, the easier it is to identify who that senior management is. The focus is always on general corporate procedures and processes rather than individual action and decision making for the corporate manslaughter. Now, under sentencing guidelines, judges can impose fines according to an organisation's size and turnover. And you mentioned some of the fines already handed out, Richard, but arguably, firms convicted of corporate manslaughter with a turnover of more than £50 million can face fines of several £1 million and up to £10 million for pure health and safety offences. So the Corporate Manslaughter Act is an important act to bear in mind, because the organisation that many install as the corporate body that they've created could be subject to corporate manslaughter charges. Individual directors at fault, however, for work-related deaths, they're covered under what we call common law, not covered by a statute like the Health and Safety at Work Act or the Corporate Manslaughter Act. Where there's a fatality, it's covered by common law, and a director is accused of causing a workplace death and can be prosecuted for being grossly negligent. And in order to be negligent, first of all, they have to owe a duty of care to the deceased. Then they have to have breached that duty, and that breach must have caused the death. But it's important to note, Richard, that mere negligence isn't enough. The duty of care, the failure of the duty of care, has to be gross. It's this word gross again. So in other words, it has to be so extreme that the action or inaction of the director is considered at a criminal standard, i.e. his or her conduct fell far below what's reasonably expected. And that sometimes can prove difficult for the prosecution to prove. But if they do prove it, then the penalties are severe, in that an individual can lose their liberty for many years, and also can incur significant fines as well.
Going back to what you said earlier, am I right in understanding that you can have the criminal case and the civil case running concurrently?
Yes, you can have. I mean, as you're probably aware, and those of you who've not been living underground for the last few years know that you've got 3 years to bring a claim. You know, we've all been subjected to these calls, haven't we? Have you had an accident in the last 3 years? That means that you have 3 years from the date of accident to bring a civil claim for personal injury. So it's entirely possible that the civil claim can run alongside the criminal case, which in Nick and I's experience can take several years to come to court because of all the evidential issues and all the considerations that the prosecution undertake. So it's very possible that that can happen. And another aspect that people need to be aware of is that there can also be an inquest. If somebody's died, then it's very likely that there will be an inquest opened into the cause of death. So an installer may possibly find themselves involved in a criminal investigation, a civil claim, and also an inquest as well. So there's a lot going on, and a lot of different courts that they may have to be exposed to as part of an unfortunate incident.
Thank you for that. In terms of the liabilities, where does insurance come into play? Can you insure yourself to keep out of jail, as it were?
Well, you can't insure yourself to keep out of jail, because obviously that's a criminal investigation. No insurance policy would ever say they'll keep you out of jail. What you can insure yourself for is the costs of being investigated. If you have an insurance policy, then that policy, which you should check very carefully, may well cover you for the costs of an investigation, which can be very significant because the investigations can last several years, criminal investigations, and it will also hopefully cover you, and again it needs to be checked, for the costs of a claim. So the personal injury claim, if the insurance policy covers you for employer's liability or public liability, so injuring somebody in your employment, or somebody in your employment injures somebody else, then it can be covered for that. And also public liability, somebody who's not your employee is injured or killed as a result of your negligence, then the public liability would start, and it would cover you for both the damages paid to the individual as well as the costs, their solicitors' costs and your own costs. So an insurance policy is a very important document and a very important consideration for everybody.
You mentioned about checking the insurance policy carefully. I can imagine that a number of our members may be very good at automating gates, but not necessarily reading fine print. Is that an area where brokers would be recommended from your point of view?
Well, brokers are very important. I mean, they are the intermediary really between the individual and the world of insurance. So they're able to review and assess what may be the best policy for that individual. And they'll also importantly give them advice on the levels of cover. So just as, you know, with your household policies, Richard, you may have, you know, an excess that you're carrying, or in your driving policies or whatever. There's all these different sort of ramifications that need to be considered. So it is important, I would say, that if you have access to a broker, that you do ask them for advice on the levels of cover that the policy would offer them, essentially.
Thank you. In addition to those questions, we regularly get asked questions by our members, so I've got a few of those. If I could pass them off to you. We talked about fines earlier, and they seem to vary across the board, from relatively small figures to larger figures. And you mentioned earlier it can be up to millions, and then a jail sentence for one instance. Why are they so different when some of the safety issues appear to be the same?
Well, Richard, much depends on the offence charged and the circumstances of the incident and the offender. As Helen referred to earlier, then if we are dealing with a fatality, then an individual installer could face a gross negligence manslaughter prosecution and then be at risk of a prison sentence. However, a corporate entity or company can only, in similar circumstances, face a corporate manslaughter charge and be at risk of a fine. In circumstances where injury is caused by a gate, or there are breaches of health and safety legislation that could lead to an injury, then a prosecution is most likely going to be under the Health and Safety at Work Act, which could attach to an individual installer or his organisation, or indeed both. Assuming, in answering the question, that we have then arrived at a sentence hearing, then the judges then must follow sentencing guidelines which set out specific criteria which will affect the sentence. And put very simply, this is an equation, as if you like, where the first consideration is culpability of the offender. So that is the degree of responsibility they may have for the incident. Add to that is the risk of and seriousness of what harm that could occur. And this arrives at a harm category. And those two factors are then considered against the organisation's or installer's turnover, which gives a starting point for the fine. Again, crudely, the higher these figures are, then the higher up the scale on the guidelines the judge will look at for the starting point of his sentence. The court then considers aggravating and mitigating factors and arrives at a final sentence. So it does allow for considerable variation to tailor any sentence, particularly financial ones, depending on those available circumstances and the personal circumstances of the individual or organisation.
Thanks, Nick. You mentioned being prosecuted under the Health and Safety at Work Act. Why is that more commonly used than the supply of machinery, safety regulations?
Well, it is the prosecutor's choice as to which legislation they prefer. And very simply, the Health and Safety at Work Act does provide a greater suite of offences to prosecute and is more attractive to a prosecutor as it can afford a judge to impart greater sentences. And again, if we are considering fatalities, then we are looking at completely different offences, namely gross negligence manslaughter and corporate manslaughter.
Thank you. Another question that we get asked quite often is, if someone uses defence that they have installed the safety devices in accordance to the British standards, force limitations and photo cells, for example, but the gate still caused a serious injury, would this argument carry weight in the eyes of the law or the courts?
It may. I think again, we have to look at the circumstances of the installation, really, as whilst those standards have been created or devised, the appropriateness of the safety features and their suitability also has to be considered in respect of the individual gate and its setting. It certainly can't be the only things that an installer considers, and instead he or she should really ask themselves, have we left a gate, or have I left a gate that is incapable of causing injury when used in the way it was intended?
Sticking with that same point, in the context of the standards, the Health and Safety Executive have said that following the standards wouldn't necessarily lead to a safe installation. Would all installers be expected to have heard that message, even if it's sort of buried on their website, as it were?
There will be an assumption that if a prosecution was to follow, that information is understood by somebody who is acting in a professional capacity to deliver the service that they have set themselves out to do. There is information there and guidance out there, and it should be something that an installer does look to do to familiarise themselves with applicable guidance around the job that they do. Indeed, the Health and Safety Executive's website is a very good starting point for anything in relation to this, as they do publicise general guidance and approved codes of practices.
If an installer is forced to undertake an action or work that he believes will lead to an unsafe gate, would he be liable?
Potentially, if she or he has clear knowledge that they've left a gate in a dangerous condition, then they clearly would be liable.
And the other side of that coin, if the installer were to refuse to carry out the work and lost his position, would he be protected by the law there?
He may have recourse under the employment law regulations, and I don't profess to be an employment lawyer, and it may be one for colleagues to assist with further. But for example, I could consider there may be circumstances where, if they are effectively being forced to undertake, in their eyes, a certain pathway in terms of work that they know is unsafe, and they raise that issue properly and bring it forward to their employer, who then takes action against them in trying to dismiss them, and they may have recourse by way of constructive dismissal or wrongful dismissal.
We touched on insurance earlier. Will insurance cover civil gross negligent corporate manslaughter? We've always been under the impression if the court of law finds you guilty for the latter two, insurance would be invalid.
I'll pick up on that, Richard. Well, not necessarily, no. And again, this is why your insurance policy needs to be looked at very carefully. If you are charged with the most serious offences of manslaughter, either as an individual or as a company, it's very possible that your insurance policy will respond. It may have an upper limit to it, which tends to be around £5 or £10 million, and that's taking into account considerable potential legal costs. I mean, some of these cases can last several weeks because they may involve multiple experts. You might have QCs and junior barristers representing you. They can be costly, but just because you've been charged with that level of criminal offence does not negate an insurance policy. So again, it's very important to check this and to ideally ensure that your policy is going to respond to these most serious of offences, as well as offences under the Health and Safety at Work Act.
One last question. Is a disclaimer relevant for an installer to try and remove responsibility for a gate that has been installed?
In a word, no. It's an established legal principle that you cannot exclude liability for death and or personal injury. And so in those circumstances, it doesn't carry any weight.
That's really been incredibly helpful. I'm sure our installers will join me in thanking you both, Helen and Nick, for sharing your extensive knowledge with us today. We will be creating some fact sheets based on today's podcast, which will soon be available on the GateSafe members area. We very much hope to bring you another legal podcast in the near future. So if you have any questions that you would like Helen or Nick to respond to, please send them to us using the GateSafe email address, info@gate-safe.org. Thank you very much.